what becomes the lesson of this whole thing? You have a judge who is on the take, who throws a person in jail literally for political purposes to stop any other lawyer for challenging or from challenging these bribes. That's what this was all about.
He's home at last. After 18 months of solitary coercive confinement, Dr. Richard I. Fine knows intimately the ugly might of the California judicial system. Has he learned his lesson? He's learned what is now at stake in the future of our country. You won't want to miss what he has to say coming up next on Full Disclosure.
Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Full Disclosure has spent the better part of the last 2 years bringing to light the alarming problems with the California judicial system. Being the news behind the news, we've spent dozens of hours documenting the sinister encroachment of county governments as they move to control the local judiciary for their benefit. As you will see in this 4-part series, this insidious encroachment is threatening the entire justice system, where the essence of a fair trial is being lost forever. This story of Dr. Richard I. Fine is just one account of this disturbing abuse of power. In this final part 4, we interviewed Dr. Fine in his home. We explored with him the ramifications of standing on principle and not backing down when fighting for what one believes is right. All Dr. Fine had to do was answer some questions, and he wouldn't have had to pay such a dear price. Can you tell us why you decided not to answer the judge's questions and rather sit there for 18 months rather than being on the outside fighting?
Oh, it's a very simple answer. There is really no choice in the matter. See, because by having answered the judge's questions, I would have given in to the judge's illegal ruling, and there would be no way to obtain a legal ruling on whether the judge should have recused himself from the case. The only way that I can get a decision from a court saying that the judge should have recused himself and get the courts to follow the Supreme Court precedents is to refuse to answer the questions and stay with the tack that the judge should have recused himself. That was it. There was no choice in the matter. If I was going to answer the questions, I could just forget about the whole thing, answer the questions, pay the money, go on my way. And forget about the entire concept of judges receiving payments and sitting on cases and deciding in favor of the county. That's gone, emasculated, wiped out.
Alone in a concrete cell for 18 months. Lights on for 24 hours every day, relentlessly. No windows, no access to the outdoors. It must have been hard. We asked him, what was his darkest day?
I think the darkest day was the day that I found out that the U.S. Supreme Court had turned us down. Because the district court I understood, because I knew, that they were just totally off the wall. The Ninth Circuit I understood because we had caught them taking money and having relationships with the County of Los Angeles. The U.S. Supreme Court, I felt, would follow the law and probably just send the case right back and order a writ of habeas corpus to be filed. And instead, the U.S. Supreme Court refused to let me out under the due process part that Yaffe ultimately leaves me out under. And they refused to take the case and refused to send it back and order a writ of habeas corpus be filed. And I think it was in that point in time that I fully recognized that the corruption, when I use the word corruption, not only the corruption of the payments, but the attitude of the abuse of power to allow the corruption to exist and stay within the system had gone so far that the entire system was undermined.
But in his optimistic way, he even turned that bitter disappointment into a positive.
But that day that ended up with greater resolution, because you have a dark day and then you come back and you say, well, let's recognize it. If this is what it is and it's this bad all the way up, we've now shown it, we've now proved it, and we go on from there to fix it.
Considering the tremendous personal, emotional, and financial cost of going to jail for 18 months, we had to ask this most significant question. Would you do this all over again?
The answer to that is yes. The only qualification is that I'd have to think twice about it if I knew going in that I was going to be in jail for 18 months, because at that point I would have to have some very, very serious discussions with my family as to the effect upon the family and everything else. As I said earlier, I thought that the system would work and I would have been out within 5 days. And that was a major, I'll say, misjudgment on my behalf, because of the fact that on March 4th, where I was standing, my research showed that every Supreme Court precedent was in my favor. I did not count on the fact, and I have to say I did not take into consideration the fact that every court up through the United States Supreme Court would deliberately refuse to follow those precedents.
How did he survive? The maximum term for being sentenced to the county jail is 1 year. Dangerous felons are released after having served only a portion of their sentences. But he was never convicted of any crime and was never sentenced. All of his appeals were denied. He was stuck in his solitary confinement with no hope, no foreseeable way out, basically forever. What was it that kept him from breaking? What was it that gave him the strength to soldier on and maintain his always positive attitude?
There is someone upstairs taking care of me. And not only taking care of me, but showing that we as a country will actually prevail in all of this. Because no matter what these people did to keep me in jail for 18 months, and no matter how many laws they broke, and no matter how many decisions they refused to follow, we had these epiphanies that took place. I mean, Yaffe out of the clear blue sky, after having refused to let me out on one day, decides literally within 24 hours or whatever it was that he's going to let me out on his own motion. I mean, here this man has been fighting me for 18 months, doing everything possible. The courts have been fighting. Everybody's been fighting to keep me in jail, and suddenly I'm out. It's very interesting that following the procedures didn't do it.
Following the procedures, following the laws, doing what he has successfully done all of his professional life didn't do it. Some other power gave him his freedom, and now that he's free, watch out, world.
Cover-up is over. It's out in the open. It didn't work. The issue didn't die. I didn't die in jail. The issue is alive, and we're going to restore the judicial system.
As a result of the retaliation by the judges, Dr. Fine was disbarred in California. He can no longer practice law. When we come back from this short break, Dr. Fine will explain how the state bar worked in collusion with the justice system to ruin him. We'll be right back.
In the government, there's a phrase used to restrict access to information. That phrase, need to know. At fulldisclosure.net, we want you to have all the information you need to be an informed citizen, unlimited access to all the information we've gathered on our TV show, and if you can't watch us on your local cable station, streaming video of complete shows when you want them. Fulldisclosure.net, when you need to know the news behind the news.
Welcome back to Full Disclosure and the final part of our series, The Cost of Courage, the story of Richard I. Fine. We asked Dr. Fine to explain how the state bar conspired to take away his ability to fight within the legal system.
The disbarment proceedings were initiated by the state bar, and at the time that the complaint was filed, Sheldon Sloan, who was the lawyer for Jerry Epstein, was the president of the state bar and a member of the Board of Governors of the state bar. Jeffrey Blythe, who was another member of the state bar and the succeeding president to Sheldon Sloan, was the lawyer for LA County in the Delray Shores case. He did the lease between his firm, Munger, Tolles and Olson, represented the county in doing the lease between the county and Delray Shores for the land upon which the Delray Shores complex was sitting.
So rather than fight Dr. Fine in court, the officers of the state bar used their power and authority to emasculate Dr. Fine by taking away his ability to practice law.
So you knew at that point that this whole state bar proceeding was not only suspect but somewhat corrupt. So the whole thing was a trumped-up charge. In January of this year, 2010, filed a fraud complaint in federal court against the state bar. That complaint is still pending. The U.S. District Court, to this day, has done nothing about that complaint, even though the state bar defaulted in the time to answer the complaint and then filed a late motion to dismiss it, and the court issued an order to show cause as to why their motion should not be stricken. We are now sitting on almost 1 year since the filing of that complaint. And that complaint says that the state bar's disbarment should be voided and annulled based upon fraud on the court.
Would you say that Jerry Epstein's attorney, Sheldon Sloan, who was president of the state bar at the time the proceedings were begun against you, had any impact on the state bar trial and on the charges against you? Do you think he influenced that action?
Absolutely. There's no question about that, because there's a law that says that he had to disclose his interest of being against me in cases, as did Jeffrey Blythe, and as did the controller, Laura Chick. And if they didn't, they committed a misdemeanor. None of them made these disclosures. So under the law, they all committed the misdemeanors.
Once again, the legal system ignored its own rules and procedures to punish Dr. Fine. We asked Dr. Fine if this continual monkeying with the rule of law creates any liability for the county, especially if citizens can't get a fair trial.
Absolutely. The liability that exists is called fraud upon the court. And what happens is that if you have fraud upon the court, any decision or order of a judge is void. The county has an obligation going into a courtroom to disclose that it is paying the judges this illegal money. The county, to my knowledge, has never made that disclosure. The judge has an obligation to disclose that he is receiving the illegal money. The judges have never made that disclosure. The result is that every case where the county has been a party and the judges receive that money is now void. And there are United States Supreme Court cases that hold that when you have fraud upon the court, every judgment and order of the court is void because the court did not have subject matter jurisdiction. Cases are United States versus Throckmorton as far back as 1878, and Valley versus Northern Fire and Marine Insurance Company.
Every case involving the county is void? What a staggering concept. The fact is, Dr. Fine has been loudly declaring that the judges have been and still are engaging in a criminal act, no matter what the legislature did when they passed SBX 211.
And the criminal part of it is obstruction of justice. Now, interestingly enough, the immunity, the retroactive immunity that went to the judges did not cover obstruction of justice. It only covered the payments. So the judges did not receive any immunity for obstruction of justice.
That means all of the judges who have taken the payments could still be prosecuted, and Dr. Fine is aggressively pursuing this.
I have asked the Steve Cooley, as the present district attorney, to prosecute the judges for that. I have asked Jerry Brown, as the present Attorney General of California, to prosecute the judges for that. And I have also, at the federal level, asked Attorney General Holder and the United States Attorney in the Central District of California to prosecute the judges under federal statutes, which are denial of civil rights statutes, for that. As of the present time, despite a 23-page report that went in excruciating detail on the issues of obstruction of justice and other violations, I have not heard from any of these people that they have even opened a grand jury investigation, much less gone in and started the prosecutions.
Once again, the justice system is ignoring the magnitude of this critical situation. It all boils down to one simple rule.
A judge cannot take money from a party irrespective of the motive. Until we get that legislation, judges like Judge Yaffe and all the judges in California are going to be taking illegal money, and the courts are not going to be doing anything about it.
So now it requires legislation to stop it. But we already have laws forbidding these extraordinary payments. It's our state constitution. And it clearly mandates that only the state can pay the judges. And SBX 211 was legislation which could not modify the Constitution. That would require a vote of the people. So guess what? The feds are coming. Judge Porteous was just impeached and convicted. We'll hear about what happened to him when we come back from this short break. We'll be right back.
For the news behind the news, wherever and whenever you want it, go to fulldisclosure.net and get programs on topics affecting you, weekly updates and alerts on hot topics, video streaming of Full Disclosure episodes. It's award-winning, hard-hitting, corruption-fighting news coverage. And it's only available at fulldisclosure.net. Fulldisclosure.net, the news behind the news.
Welcome back to Full Disclosure and the final part of our series, The Cost of Courage, the story of Richard I. Fine. Recently, there was a federal case that perhaps can shed some light on what is happening here in California.
Within this last week, the United States Senate has convicted New Orleans federal judge Porteous for having lied to the Congress when he became a federal judge. And the subject of his lie was that he had accepted money from parties appearing before him while he was a state judge. So they got him both for lying to the Congress during his nomination process and also for taking the money from a party in front of him.
Dr. Fine sees this as 100% applicable to his case here in California.
All of the LA Superior Court judges, and particularly Judge Yaffe in my case, by having taken money from a party in front of him, has committed a crime. And it's the exact same crime that Judge Porteous has been first impeached by the House of Representatives and then convicted by the United States Senate and being removed as a federal judge. What this means is that in the situation of my case where Judge Yaffe has taken this $500,000, by the way, which is illegal, and gone and sat on the case, the U.S. District Court, the Ninth Circuit Court of Appeals, and the United States Supreme Court has done nothing. And yet, in the situation of Judge Porteous, who did exactly the same thing, they removed him from being a judge. The result is that when the courts are allowed to govern themselves, they will do nothing to discipline their judges.
How widespread is the problem here in California? His response was very disturbing.
A report came out in 2009 after the Sturgeon case. The courts were required the Judicial Council was required to report to the state legislature as to how many judges were receiving payments from counties. And it turned out that 90% of the judges in California were receiving these payments, these illegal payments from counties. So 90% of your judges are receiving these payments. And when you look at the retroactive immunity that was granted to every judge who had received an illegal payment from a county, that shows at least 90%. If you translate that into the California Courts of Appeal, that's going to be 90% of the appellate judges that receive the payments. Take that to the California Supreme Court, it turns out that 6 of the 7 sitting California Supreme Court judges had received illegal payments from counties while they were sitting as Superior Court judges.
But the feds don't seem to be hurrying to California and indicting and throwing the California judges in jail. Why not?
What we have cases like the Caperton case that essentially sets a barrier of $3 million given into a campaign fund is enough to deny due process. But the judges really don't follow that, because in my case, the Ninth Circuit held that $500,000 being given to Judge Yaffe by LA County wasn't really enough to deny due process. So we now know, and the United States Supreme Court didn't take the case up. So basically, we can have sort of a rule of thumb that give a judge $500,000, bribe him with $500,000. That may not be enough to deny due process. It may be a bribe, but it's not enough to deny due process. Give $3 million to his campaign fund, and that'll be enough to deny due process. So the bottom line of this is that the courts are complicit with parties giving money to judges. That's the bottom line of it, all the way up to the United States Supreme Court. So we cannot look to our judicial system to be able to cure the problem of corruption. They are incapable of self-governing themselves.
But we can't look to the legislature. They passed Senate Bill SB X 211 to alibi the judges and let them off the hook. Or so they thought. According to Dr. Fine, the continuing flow of money to the judges is no longer protected by that one-time law.
SB X 211 actually did not legalize the payments. Sturgeon versus the County of Los Angeles held that the payments to the judges from the counties violated Article 6, Section 19 of the California Constitution. After that opinion was written and it went through the California Supreme Court, who denied review, that became the law. The effective date of SB X 211 was May 21st, 2009. So those payments starting on May 21st, 2009 would run only to the end of the fiscal year. So that meant that they would be good only until June 30th, 2009, or basically 39 days. As of June 30th, 2009, SBX 11 is over. Because what happens is that a new budget has to come in LA County. Well, when they vote the new budget, SBX 11 doesn't cover that, because SBX 11 only specifically said the payments that were being made as of July 1st, 2008 would be renewed on the same terms and conditions. Those terms and conditions ended as of June 30th, 2009. When they voted the money for the judges to begin on July 1st, 2009, the county was outside of SBX 211. Essentially, every payment commencing from July 1st, 2009 is illegal again because you do not have any state legislation allowing those payments to take place or designating those payments to take place. SBX 211 did not mandate any payments to continue beyond the payments that were set up for July 1st, 2008.
And so Dr. Fine is continuing his crusade against the corruption of the California judicial system.
We've ended up with a total corruption of the system, which has now been acknowledged by the state legislature through the passage of SBX 211, which gave retroactive immunity from criminal prosecution, civil liability, and disciplinary action to both the supervisors who gave the illegal money to the judges and to the judges who accepted the illegal money. Further, at an international level, the world has recognized this corruption through the summary report of the United Nations. So we are in a position that California, and in a sense the United States, has now become a third world nation as far as the judiciary is concerned. We have dropped from the level where people have looked at us for hope and aspire to be like us to the point that they look at the United States with derision. We have got to come back from that position to go back to the place where we belong, where the world will again look to us for hope and aspire to be where we are. We know as citizens where we want to be, where we have been, and where we should be. And we will get back there through our own action, despite the action of the bureaucrats and the courts.
We want to know what you, the viewers, think. Are you ready to join with your fellow citizens and restore justice to California? If you are, please call our Full Disclosure Town Hall number and tell us what you think at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
To respond to this question or comment on this program, please call 800-867-7777 or visit fulldisclosure.net. Transcripts or DVD copies of this program are also available on our website. Full Disclosure, the news behind the news.